All right, we're live. All right, come on in, everybody. Welcome back to the Holler at the TN Holler on Twitter, Facebook, and Threads. Chris, I know you're on Threads. Thread
Yes.
it up. Yes. We appreciate all the support. Your small dollar monthly donations keep us going. As always, we have hollers hollering all over the state thanks to your support. So follow them all, check them out. Really do appreciate it. And before we get started, I just want to, as always, shout out Elisa Parker. If you're buying or selling in Middle Tennessee, do it through her. If you need some jewelry, AJ Martin. It's not your grandma's jewelry store, Chris. And if you need a lawyer, Abby Rubenfeld is a rock star, and we appreciate all their support. So thank you so much for supporting us. Today we're going to talk about something that I know has been on everyone's radar for a little while. The trans youth healthcare ban here in Tennessee that was passed by this extremist right-wing supermajority and Governor Lee during the session. There was a ruling not too long ago that blocked part of it from going into effect that people were very excited about. And then, of course, not long after that, we saw another group of judges or couple of judges rule that actually it was going to go into effect. That was this last couple of days. And we saw a really good write-up of the situation by our guest today, Chris Geidner of Law Dork, who really broke it down. So go to lawdork.com or follow him at Chris Geidner on all of your social media sites. And we wanted to get him on here to kind of explain to us why he called it a truly horrible decision, not only from a human perspective, but from a legal perspective. Chris, thanks for joining us today.
Yeah, no, thanks a lot for having me. Appreciate all that you all do in a really difficult environment this year.
Yes, well, extra difficult this year, but actually difficult every year. And, they seem to not run out of ways to frustrate, in my opinion, reasonable minded people around here. So, again.
Yeah, and I mean, if readers, if listeners and watchers don't know, I actually have a Tennessee connection.
Okay.
I'm often in Knoxville. My brother lives in Knoxville as a professor at UT, and that's where my nephews are. So
Awesome.
so I actually also have a personal interest in making sure that there is fairness in Tennessee.
Gotcha. Well, that's good to know. I didn't know that. And so people know we can see your comments if you want to comment along. So, Chris, I guess I'd love to just have you kind of walk us through this. Like, I know from a top line, basic point of view that we had this law pass, and then a judge ruled that at least part of it was unconstitutional. I think blocked the portion of the law that stops trans youth from being able to access hormone blockers, kept the surgery part in place. And then what was the decision that came down recently that overturned that?
Yeah, so really quickly, I just want to. So Judge Eli Richardson is the district court judge who enjoined the ban, and I think it is important to note that he is a Trump appointee. Like, this is not some like wild liberal judge, some ridiculous Biden judge or something. I mean, this is a Trump judge. It was a 69-page decision that went through all of this, and what he concluded, the only reason he did not conclude that the surgery ban was constitutional, all that he decided, even on that front, was that the plaintiffs didn't have standing because none of them were seeking surgery at this time. So just to get that out of the way, that's the reason why it didn't address that. And then, as you said, he enjoined the enforcement of either the puberty blocker or hormone bans that were going to be a part of SB1. And then the big part of the decision was that he decided that that the plaintiffs had shown that this was likely unconstitutional on its face, meaning just in general on all counts. And he noted that he was able to reach that decision without even looking at the specific facts of the plaintiffs. So it was just unconstitutional writ large, and he banned the state from enforcing it at all statewide. Then the state goes to the Sixth Circuit, where the appeal will be heard. They say they're going to appeal the case. They also asked Judge Richardson to put his ruling on hold. This is where it gets complicated. So you have a new law. It was due to go into effect either June 30th or July 1st. I forget, because Kentucky and Tennessee were both at the same time. So this new law was about to go into effect basically on July 1st. Richardson says it's not going to go into effect. I'm halting it from going into effect. The state is enjoined from enforcing it. Then the state says, we're going to go to the Sixth Circuit. We're going to appeal that ruling, but we're also going to ask the Sixth Circuit to stay that injunction while the appeal is proceeding. Now, when you stay an injunction of a new law, what that really means is you're able to enforce the law. The injunction halted the state from enforcing it.
You blocked the block.
The stay allows you, it halts the effectiveness of the halting ruling. Yeah. And so they go to the Sixth Circuit, and the briefing was done pretty quickly, and it was completed, I believe, like Thursday night. The state responded. And then at my understanding from having talked to the lawyers is shortly after midnight so technically Saturday morning, late Friday night, the Sixth Circuit issued a ruling saying that they were going to grant that request to stay the injunction. So they were allowing the state to enforce SB1. Now that ruling came down. I woke up on Saturday to several messages from lawyers and readers and people who are involved in these issues being like, what happened? And so I got to work, and that's the post at Law Dork. What we had was a 2-1 ruling. There was a judge who dissented. A 2-1 ruling from Judge Jeffrey Sutton, who's the chief judge of the Sixth Circuit right now. And he, along with Judge Thapar, Amol Thapar, who was appointed by Trump, Jeff Sutton was appointed by George W. Bush. And what Judge Sutton wrote was basically, we've only had this for a week. We're not certain of what the outcome's going to be, but we're going to upend the law for everybody based on our very quick review of this. I really want to stress that, because it's all, his opinion is all sort of in this modesty, we're just judges. We should let the legislature do what they want. But let's be clear. every judge who has looked at any of these type of laws across the country, including obviously Richardson, who I said was a Trump appointee, 2 other Republican appointed judges, they have all concluded in 6 different states that these laws are likely unconstitutional, or in 2 cases, they've had full trials and have decided they are unconstitutional. And yet, what Jeff Sutton and Amulthapar did, based off of a couple of days of briefing from appellate judges, from appellate lawyers, not having reviewed the evidence at trial, said, no, we're going to be the 2 judges in the country who are going to allow one of these laws to go into effect. And what they said was, and I'm sorry to keep going on here. If you want to interrupt with a question, go for it.
No, I'm good so far. I mean, I'll ask you some stuff at the end. Keep going.
What they did was, first, Judge Sutton says this shouldn't have been statewide. There was no justification for the judge issuing a statewide ruling on this. Now, his argument on that was that traditionally a facial invalidation means that there are no instances in which it's constitutional. What Judge Richardson did was basically said, well, that's the case because I didn't even need to look at the facts of these individuals' cases. So therefore, it is unconstitutional in all cases.
Can I ask, one question there. What were the grounds for which Judge Richardson decided it was unconstitutional?
Okay, so yeah, I mean, this is the true thing is that Sutton sort of did it on its head. He first said the statewide injunction was too far. But then he goes to the merits, which are there are 3 grounds that these bans are being challenged, and that Richardson found this was likely on Tennessee's ban was likely unconstitutional on all 3 grounds. There's due process. And the due process grounds are parental rights to choose the way that they want to raise their children. Some of the key cases on this have to do with parent fights of parents versus grandparents in raising their children when there are custody disputes. And then most famously, whether or not children can be forced to give the Pledge of Allegiance. And in those cases, it was established that there is a parental right to control the upbringing of your children.
Right. And Republicans here love to claim that they're the champions of parental rights.
Right. I mean, you've got all these parental right Bill of Rights that are being passed. There actually a judge in Florida used the parental Bill of Rights in Florida as a reason why the no exceptions drag ban in Florida violated the parental Bill of Rights was evidence that the drag ban went against what Florida law otherwise recognized for parental rights. So it was more of a reason why it was unconstitutional. So yeah, this contradiction is showing up in lots of places. There are parental rights for everything except for things that we don't agree with. And so the parental rights was the first ground. Then there were 2 grounds under equal protection, which is the thing that we're more used to. Equal protection is exactly what you think it is. It's race discrimination. It's sex discrimination. It's just when laws discriminate, when they classify people based on a protected characteristic, and the state in that instance has to prove either that it meets what's called there's levels of scrutiny, and it needs to pass heightened scrutiny for sex, strict scrutiny for race. And that basically what that means is for heightened scrutiny, you need to prove that there's like a really important state interest involved, and that this is close. The means you've chosen is closely tailored to that. The real question for these cases oftentimes is just, does it meet one of these heightened classifications? And in this case, the two grounds that people are bringing lawsuits is that this is a type of sex discrimination. And the reason why is sort of twofold. It is, I mean, the basic reason that judges have been accepting is this is obviously sex discrimination because these drugs are used for cisgender patients all the time. Like, we allow puberty blockers and hormones for minors, for cisgender. Various precocious puberty is something that I've learned about in these times. And there are other reasons why doctors use these drugs on children, prescribe them for children all the time. And so the judges just look at these cases and they're like, this is obviously not a health. I mean, the state's interest that they always claim is that this is for worried about the health of the children. And the judges just look at this and say, well, obviously that's not what this is about if you allow the very same drugs to be used when cisgender children need them. And so, yeah, delayed puberty there. Thank you, Joanne. And so that's the main sex discrimination. They look at it, they say, this is obviously being discriminated on the basis of sex. And so therefore it needs to meet this heightened scrutiny. And then they look at the reasons why states give. This is often where they get into discussion of like claims that, well, European countries are limiting care. And then the judges actually look at the facts and they say, well, if the state had passed a law that was equivalent to what European countries are actually doing, we wouldn't be here, because they still do allow it. They just require certain conditions to be met, which almost all people who are receiving this treatment in America do meet. Nobody's going in and just picking up hormones like candy. This is especially in the case of minors, something that often is years in the making. So that's the first means. The other equal protection means is pretty direct. It's just that this discriminates on the basis of transgender status. And the difference for transgender status is that that's not as well established in the law. That there's not a definitive U.S. Supreme Court ruling that says transgender-based discrimination gets heightened scrutiny. There are cases like Bostock, if you remember from a few years ago, that said that both sexual orientation discrimination and gender identity discrimination are a type of sex discrimination that violates Title VII of the Civil Rights Act, so employment discrimination. And there are other cases. There's a case, Smith, out of the Sixth Circuit, where these judges were hearing it, that Jeff Sutton sort of threw to the side, where the court a long time ago, relatively speaking, decided that anti-transgender discrimination is oftentimes a type of sex stereotyping, and therefore is potentially illegal sex discrimination. And so Jeff Sutton just ignored all of these. Eli Richardson said this is a type of discrimination that deserves this heightened scrutiny, transgender status discrimination. And so he blocked it on all three grounds. And basically what Jeff Sutton and Amol Thapar did was said, we don't think it's sex discrimination because it applies to both male and female children, which is sort of like the most simplistic, basic misinterpretation of equal protection law. Like, if you allowed that, you would have never had Loving versus Virginia, which was the pivotal Supreme Court case that
it's like saying
interracial marriage.
We're doing this equally to white and black people, so it doesn't count.
Yeah, exactly. Yeah. That was Jeff Sutton, the fact that, I mean, so let's be clear, just full disclosure to your watchers here. I know Judge Sutton, Jeff Sutton, was my professor for a full year in law school. He gave me 2 A's, so I'm willing to come at him. I mean, it was an embarrassing decision from Sutton. I mean, the fact that his sex discrimination section was 1 paragraph, and it started with this idea like the sentence was like, the law, first of all, the law treats male and female children the same. And it's like, if that's where we're starting, buddy, like we're clearly just going to go downhill from here. And we did. He dismissed the parental claims, this due process claim, by effectively saying, really focusing on this conclusion that he just drew out of thin air. And I wrote about in my story that he used 10 times in this brief. I mean, it was only a 17-page ruling from him. So we're talking about like probably like a 5-page section. More than 10 times he referred to this as a new, he didn't use experimental, but he said it was a new medical treatment.
Right, I saw that.
It was a new drug treatment. Like, and it's not. Like, that's just a lie. Like, no judge to actually look at the facts and sit there with these trials has ever made that conclusion, because it's so obviously false. But that was his whole basis of like, parents have no right to choose to subject their children to a new medical treatment. Like, well, that might be true, but that's not what we're dealing with here. So that was how he tossed out that. And then transgender status, he sort of sidestepped that by, I sort of previewed this, by using the excuse that nobody has explicitly decided that transgender status gets heightened scrutiny, so therefore we can't be the ones to do that. And so he sort of avoided, he said it wasn't sex discrimination because it affects boys and girls. And he said that we couldn't even consider whether it was transgender status discrimination deserving of heightened scrutiny because the Supreme Court hadn't decided that yet.
So you know Jeff Sutton, so I just want to ask, like, did they go looking for him specifically? Does he seem like somebody that they were like, we're going to go get him to weigh in on this?
This wasn't like those cases of like Matt Kaczmarek down in Texas, because this was an appeals court. So it was a random draw of 3 judges from the Sixth Circuit. However, and something that I note in my piece, I mean, this is not his first time at the rodeo. Jeff Sutton was also the sole judge to write a decision after the U.S. v. Windsor decision in 2013, striking down DOMA. He was the sole judge to write a sole appellate judge to write a decision saying that marriage discrimination laws banning same-sex couples from marrying were constitutional. He did that in 2014, which was then the case that led to Obergefell and led to the Supreme Court overturning all of the marriage bans. But that was a series of cases that the Sixth Circuit heard from all 4 states. There were cases from Michigan, Ohio, Kentucky, and Tennessee that were before the Sixth Circuit there. Those are the 4 states in the Sixth Circuit. And he had decided that time. Now, the thing is, this was, again, as we talked about, it was halting the halting. So this was where they said at the end, a line that I've just grabbed onto, that after making this extreme decision that allows a new potentially discriminatory law to go into effect, that every other judge to consider it has enjoined it, he then says, we may be wrong. It's like, I don't know if there are 7 other judges, including one other appeals court, to have considered this issue, and they all reached the other conclusion. And all that you have to do is say, we're going to keep this potentially discriminatory law on hold until we can have the whole appeal and take our time on this preliminary injunction appeal. Like, why wouldn't you do that? Like, if you're going to write in the opinion, we may be wrong. It was just and that's why at one point on Saturday I wrote, like, this is truly like not only is it an extreme opinion, but like this is like judicial supremacy. This isn't, he like sort of frames it as a modest decision that he's stepping back, letting the legislature do their thing. Judges shouldn't get involved in stopping the democratic process. And like, he's missing the main point of when judges should step in, when lawmakers or executive officials, when the government is discriminating against its people.
Right. And, I guess that brings up, first of all, I know that Senator Jack Johnson, who's one of the sponsors of the bill, he's said today that he's fully expecting this to end up in the Supreme Court. And, I guess I would ask you, do you think that's what's coming? And then also, are we just in a situation where basically the entire system's politicized because everything's going to end up in a Supreme Court that we know has been captured by, right-wing extremism and, I won't even say conservatism, but, it's a radical right court that has been politicized with judges that lied to get to where they are. And, every controversial decision seems like it's just going to end up there. So is that just what our country is now?
I mean, it sort of goes both ways. I mean, the positive possibility is that, again, every other judge to have looked at this concluded the other way, including conservative judges, including Republican appointees, including the Eighth Circuit, which is just as conservative as the Sixth Circuit, including judges who conducted lengthy trials. So there is a chance that this becomes the outlier. I was sort of, my biggest surprise on Saturday was that they wanted to be the outlier here. And that does bring me pause. It does cause me some worry, because unanimity was a very powerful message, even to this Supreme Court. If nobody had reached the opposite conclusion, I was going to feel a lot more comfortable about where these laws were going. But you do now have 2 judges, including, I think importantly, it should be noted that Amol Thapar is one of Mitch McConnell's favorites. He's somebody that McConnell has been pushing for the Supreme Court for recent vacancies. He's almost certainly going to be a serious contender if there's a Republican president come 2025 and there's a vacancy. He, in my mind, almost certainly would be the nominee if Justice Thomas resigns under a Republican president soon, mainly and bluntly because the Republican bench for non-white judges isn't broad and deep. And if the court, if the president wants to do something like that, for all Republicans talk about not caring about that stuff, look at who Trump nominated to replace Justice Ginsburg. So I think that that those 2 judges did sort of change the dynamic, but hopefully they will remain outliers. And I think we did see sort of a slightly good sign in the fact that the challenge over a sports ban, I'm blanking on if it was Kentucky or West Virginia. I think it was West Virginia, that the Supreme Court did not allow that to go into effect during appeals. So, and that was this court, that was this spring. So I do think that is a good sign that these laws are have a possibility of reaching a skeptical court, even by this Supreme Court. But it sucks, and it is disturbing that that you can have two judges like this. I should note that Judge Helene White dissented, so it was a 2-1 ruling, and she viewed the law unconstitutional, and likely unconstitutional sex discrimination. And she said that because of that, she wasn't even going to consider the due process parental rights claim or the transgender status claim, because she didn't need to for these purposes. But she did view that way. So that's why, again, I can say it's still only 2 judges. And the 8th Circuit's decision when they upheld the Arkansas injunction, the injunction against Arkansas's ban, I should note that was a unanimous decision. That was a 3-0 decision. So I mean, it's bad. It's bad for right now, obviously, in Tennessee. It's also likely bad for Kentucky, which has motions to stay the injunction there pending right now, both at the district court and 6th Circuit. And that will almost certainly be stayed because the court has already consolidated those cases, the 6th Circuit, and said that the appeal will be heard together. The other good news, however, about this is that the 6th Circuit did expedite the consideration, and they said that they want a final decision on the preliminary injunction by September 30th. So these are moving quickly. And
but in the meantime, you've got, kids that are being forced off of their medication.
And, the Tennessee's, if they are currently on prescription, they have through the 24. And that was one of the rationales that Sutton used for not worrying about this, in light of the fact that they're going to decide their full decision by
September.
But
theoretically, the reason that it was a year is because they're going to phase off of it and not do it cold after a year. So you've got kids that are theoretically already.
Oh yeah, no, it's awful, and it's a can we say a bullshit excuse on here?
Yeah, of course. Say whatever you want. I mean,
and it also means that no children who were talking in parents, children, families who were in discussion with doctors currently, none of them could start.
Right.
So even if they'd been speaking with people for the past few months or year even, they're not starting now.
Right. I wanted to ask you one other thing before I let you go, and thanks for spending so much time with us. I don't know if you saw this, but recently Vanderbilt handed over all the medical information for people who have been getting trans care at Vandy, or have even asked for it, I think, to Tennessee's Attorney General, who's a pretty right-wing guy named Jonathan Skrmetti. There's a big uproar. Obviously, a lot of people that we've heard from are pretty scared about it. What right does Skrmetti have to do that?
Yeah, he's the named plaintiff, but there are several people. He's the first name, so we see Skrmetti in the caption on the case. But other people are named as well. And I'll be honest with you, I don't want to say too much on that because I kept seeing it. As you know, I've been dealing with the end of the Supreme Court term too.
Right.
And that I did see from you and others that sort of going through, and that is something I want to look into here. Oftentimes there are things, especially at the district court level, that are turned over as part of litigation under, there's been things in this case turned over under seal, which means that the only people who have access to it are the people in the case. There also are things that are turned over redacted. It's possible that this information was turned over with no identifying information. I would need to check into the specifics of
Gotcha.
how it was handled before I'd want to say whether I felt like the things had gone too far. I do think that if all personally identifying information is removed, that there is a chance that it was information just to make a determination of how common these procedures are, how common these prescriptions are, how many people are being treated in Tennessee. And honestly, that is something that, again, if patient records are being completely protected, I obviously, if they're not, I'm like up in flames on that. But if they are being protected, that's something that could actually work in the favor of the plaintiffs, because it could show that this is something that is important to a number of Tennessee residents, and that is being handled responsibly, is being carefully carefully monitored by medical providers and sorts of things like that.
Right.
And I think we have seen that if you look at the main decision that I think is helpful to look at is Judge Hinkle's decision in Florida. There was a Medicaid case that had to do with banning Medicaid dollars being used for transition related care in Florida. And there was a whole trial. There was a 2-week trial for that. And there's a lot of really important information in his decision about sort of what he learned, honestly, going through the process of that trial, and why I think it sort of led him to an even stronger position against the law than when he went in. That I think would be helpful to looking at how these sorts of things, finding out what actually happens in these instances, is something that does a lot to take away from sort of the ignorance and the
Right.
just fact-free claims, sort of like what we saw from Judge Sutton on Saturday.
Right. Well, no, I think absolutely destigmatizing it. That's why we've tried to have people on here to put a face on it. We talked to the mother of a trans minor that was going through care. She was up in arms about the Vandy thing, and then we had actually a trans person on here not too long ago. So it's important to humanize it. But really appreciate you coming on here, Chris. Again, it's lawdork.com.
No, thanks a lot.
And at Chris Geidner on all of your social media, breaking down the decision from a legal perspective. I learned a lot from his article, and so you should all check that out at lawdork.com. Chris, thanks so much for coming on here.
Thanks a lot. Hope you're doing well.
All right. Take care.
Bye-bye.
Bye-bye. So that was Chris, lawdork.com. Wanted to have him on here just to go through the decision. I think it's important to remember that according to Vandy, there were only a handful of minors that had surgery, and the ones that did were 16 or up and had their parents' permission. I think it was like 5 or something in the last 3 years. So the people that are making a huge ordeal about that and making it sound like it's happening constantly, that's just not true. I'm glad you think that was informative for your monkey. And Diane, appreciate you guys watching. And then, the other side of it is the hormone therapy, which, you hear parents talk about it who have gone through this. And I'm not going to sit here and act like I'm familiar with the process or, understand what it's like to have a child going through that or to go through that myself. But these are people that are making the decision for themselves. And anybody who sits around and talks about parents' rights or small government or freedom to push for these laws to intrude into the lives of these people especially with the hormone therapy, which is allowed in other circumstances, but not in this circumstance, you're just hypocritical. And if you really believe in that stuff, you should want the government to stay out of healthcare decisions. Same thing with women's reproductive rights, and so many of these issues cross over in that way. So, this trans youth healthcare ban, they're framing it like, oh, they're stopping thousands of surgeries and quote unquote horrible word, but one that even the news runs with, mutilating kids. Like, this is a handful of surgeries that happened to 16 and over where parents were involved and signed off on it. And then one of the amendments that was offered during the process of the law getting passed was by Bo Mitchell offering an amendment to stop elective surgeries for all minors, all elective surgeries, nose jobs, boob jobs. These are things that minors get. And if you really think circumcisions, these are things that minors get. And if you really think this is mutilating kids, well, why isn't that mutilating kids? And so Bo offered an amendment. Let's stop all elective surgeries for all minors. And they voted it down. Why? Because this is about persecuting trans kids and trans people and hate. And there was a clip recently where Trump was talking to his people, and he mentioned something about trans people, and they gave him a standing ovation. And he was like, wow, I say anything about trans and you all go crazy. 5 years ago, you didn't even know what that was. That's exactly right. This is all about fear mongering, ginning up fear to cling to power politically, especially here in Tennessee. And that's always what this has been about. It's not about protecting kids. How many different ways do we have to see kids getting persecuted and abused by their own colleagues in the legislature? David Byrd, they let him stay. They didn't do anything about that. The SBC convention, abuse cover-ups. Bishop Sticka, who just resigned from the Knoxville diocese, they had him give the prayer on day one of the Tennessee Senate. Lieutenant Governor McNally brought him in to do that. So it's not about protecting kids. It's about hate. And this ruling shows that their laws aren't even constitutional, but there are judges that will overturn it anyway. And now we have a compromised judicial system where who knows how this is going to end. So, I would just ask you to consider the hypocrisy of pushing a law that invades into people's healthcare decisions in this way, based mostly on misinformation. And it's the opposite of freedom. It's persecution, and we need it to stop. And again, I'm not saying this is somebody who claims to understand everything about being trans or having a trans child, but in this country, if you really care about freedom, people should be free to make these decisions, especially when, in many instances, these are kids who are questioning whether they even want to live anymore, which we have heard from their own mouths on this program and behind the scenes over and over and over again. So if you had to choose between your kid continuing to live or taking these hormone blockers, the choice would be easy. And stop vilifying these parents, stop vilifying these kids, and let these parents parent. Thanks for watching. We'll see you next time.